Section 66A has been in use recently due to its vague drafting, which has led to a series of controversial judgments. Section 66A was brought into the Information Technology Act of 2000 by a 2008 amendment. The legislative intent of its drafters was to curb crimes such as cyberbullying, cyberphishing, cyberstalking, and sexual harassment through stealing of private photos. The Section 66A derives its legality from the Section 127 of the UK Communications Act 2003. This section of UK Communications Act was recently read down by the House of Lords in UK since it did not fulfill the legislative intent of its drafters. Section 66A of the Information Technology Act includes vague terms such as annoying, grossly offensive, menacing, causing annoyance, which made way for the state machinery and the state police to interpret and misuse it for the purposes of politicians and other persons in power. It is interesting to note that only 3 MPs opposed the 2008 amendment that brought Section 66A into the Information Technology Act of Shreya Singhal versus the Union of India 2015 was filed in the backdrop of cases such as Asim Trivedi's case, the Facebook case of the 2 girls in Maharashtra who were arrested for merely commenting on the Bandh in Mumbai after Bal Thackeray's funeral, and the case in Rampur where a teenager was arrested for merely commenting in Facebook on Azam Khan. So I'll be talking more about the Shreya Singhal versus the Union of India case. Now, in this case, this is known as a landmark case for the entire controversy of Section 66A. How? Well, the arguments that we've been talking about were based on fundamental rights. Article 14 mainly, which talks about the liberty of people. Now, what question that has been raised in this whole case was that creating separate media. Now, creating separate media, as in earlier the court had established wherein film media should be a separate domain. Similar to that, an internet domain was also being created. But then, as opposed to the government side, they say that they have invoked Section 69A. Now, what Section 69A talks about? Section 69A talks about how the government has a right to block sites, and if that is allowed, then why not Section 66A? What the court have to say about this? Well, it is obviously the government's right to block certain sites for the well-being of the people. At the same time, Section 68A also protects the well-being of the people. But then, having said that, the court mentioned that it is violative of fundamental rights, namely Article 19(1)(a) and 19(1)(b). And it is a basic notion that any legislation which violates the fundamental right, it cannot be held admissible. Many of my colleagues have mentioned earlier that cases such as the Facebook case where 2 girls who had posted about the Bal Thackeray were arrested. Then we have the Asim Trivedi case. Then we have cases in Uttar Pradesh wherein a simple comment or a like can get you in prison. Now these itself act in a very arbitrary way, and the court has to say that this vagueness in the law, the open-endedness in the law, this creates problem and creates a mechanism for the government to use it in its own favor. In order to prevent this, the court decided to strike this article down.
Rajul from Mopi Chandra Global University, and I'll be talking about the disadvantages of deleting Section 66A of the IT Act 2000. Now, the Apex Court, in its decision, Shreya Singhal versus Union of India, was justified in deleting Section 66A of the IT Act, as this section was infringing upon people's freedom of speech and expression, which is guaranteed to them as a fundamental right under Article 19(1)(a) of the Indian Constitution. However, we can't forget that not having a provision like 66A altogether can do more harm than good. It was Section 66A which had curbed crimes like cyber stalking, online bullying, sexual harassment through stealing of private pictures, cyber phishing, etc. And now, this abrupt deletion of the Apex Code of Section 66A is going to have a lot of negative repercussions, as it would cause seriously to the life and dignity of women and girls. We already know that internet is a separate, fast-growing domain, and one post on the internet can go a long way in destroying someone else's reputation and dignity. Therefore, in my opinion, the blatant deletion of Section 66A should not have been the way to go. The correct solution was to amend the section in such a manner which would make sure that people's fundamental rights weren't infringed upon, and there was no misuse of the section by the police and the political class.
Under 66A, if an authority takes action, the offence itself is bailable. What does that mean? It means that if a policeman arrests you or seeks to arrest you, he must on his own, without anything more, grant you bail there and then. In other words, he cannot take you to jail. If anybody has done that in the past, it is that enforcement authority which has violated the law. The law by itself doesn't allow you to be sent to jail. But if somebody contrary to the law takes you to jail, the fault is not in 66A, but the fault lies in the person who is enforcing that law.
A lot of information to take down at one go, but Section 66A is something which everyone, whether you're from legal background or non-legal background, should know, because come on, everyone goes to Facebook, everyone tweets, everyone goes to Gmail. And having said that, a little bit of information in the air, I think my personal opinion, it should be amended, because cyberbullying, cyber phishing, stealing of pictures is something is a menace not only in India but all around the world, and that's what I personally feel. But then I leave it up to you as to what you think should be done, whether it should exist, whether it should not exist. Whatever you are, please post a comment below and do subscribe. Until then.